Of course, your comments are welcome. We are live on X Spaces, on Facebook, on YouTube, and of course on myjoyonline.com. Your comments will be shared here on this program. This is A Pulse. My name is Elton Brobe. Now, this afternoon, we are starting from the stables of the Supreme Court of Ghana, and the court has, by a 2-3 decision, dismissed an injunction application by the Member of Parliament for Old Tafo, Vincent Asafua, challenging President Mohammed's decision to suspend Chief Justice Gertrude Tokono by a 3-2 decision, with Henrietta Mensah Bonsu and Ernest Gau dissenting. His Lordship, Justice Bafuboni, Justice Amadou Tanko, and Justice Yoni Kolende voted to dismiss the application. Now, let's take a look at how the voting went. And of course, so this is how it went down to the Supreme Court dismisses injunction challenging the Chief Justice's suspension. So the 5 members that sat on this panel, 3 out of them voted to dismiss the application. And my colleague Latif Idrisu is our legal affairs correspondent. He's in the studio and is going to help us walk through the graphics as we have it. So Latif, if we can help understand them of what we have on our screens this afternoon.
Yes, so just to deal with the graphics that we have. So we have 5 members sitting on the panel. And let's state for the record that this is a different panel compared to the panel that started this particular case. And we'll get into that, I'm sure. Going forward. So we have Justice Geu and then Justice Henrietta Mensah Bonsu, both of them dissenting. And then we have Amadou Sule, Justice Amadou Sule. We have Justice Bafuboni, that is the acting Chief Justice, and then Justice Yoni Kolende, all 3 of these voting to dismiss the said application. And you have it on the screens right now. We have the acting Chief Justice, Justice Bafuboni. We have Justice Amadou Tanko. We also have Justice Yoni Kolende. So these 3 you find on your screens voted to dismiss the application brought forth by the Member of Parliament for Old Tafo. And then you have 2 other judges who voted to sort of dissent on the application. So you have Justice Henrietta Mensah Bonsu and Justice Ernest Geu. These were the dissenting voices.
They voted to say that the application
must hold.
Must hold.
Yes.
And that, according to them, the suspension was not right.
It's not right. And so the warrant that was issued by the President to suspend the Chief Justice, according to these 2, Justice Henrietta Mensah Bonsu and Justice Ernest Geu, that must be respected, and the President's order has to be suspended. All
right. So initially, this was not a panel initially.
Exactly.
This panel that took the decision today
it's a reconstituted.
Went through some kind of modification.
Exactly.
So first, let's establish the initial panel that was constituted by the suspended Chief Justice.
So those who are absent on this particular panel are Justice Wamang and then Justice Asiedu. And now we all know that these 2 justices have been appointed by President Mahama to sit on the committee that is investigating the allegations as captured in the petitions. So they couldn't have been present on this same panel hearing the matter and then be on the same committee that is going to investigate the allegations that have been made. Clearly, that would occasion some level of conflict, if you like. And so that was the argument that Justice Amadou Tanko made to the learned lawyer, the former Attorney General, Godfrey Adame, when he insisted that the acting Chief Justice
himself
ought not to be on the panel.
On this panel.
Because in the minds of the former Attorney General, Justice Bafuboni stands to be the ultimate beneficiary of the outcome of the procedure that has been triggered by the President.
That is, in event that Gertrude Tokono is removed as Chief Justice of the Republic.
Exactly.
Because he is already acting.
Exactly. So, and then for someone who stands to benefit, you cannot set up a panel.
You take a decision that affects the person for whom you are acting in her capacity.
Exactly. Because you benefit at the end of the day. Then the argument by the panel was that, no, they quoted Article 1446 of the Constitution and says that once he is acting as a Chief Justice, that is an office that he, as a person, is occupying.
Right.
He is not barred from undertaking his role, his duties as an acting Chief Justice. And so the argument by the former Attorney General doesn't hold. In fact, this particular section went on for a very long time. It was back and forth with the former Attorney General quoting some provisions in the Constitution, quoting some papers that have been published, quoting the Ghana Law Report from the 80s, and all of trying to make a case that indeed Bafuboni ought not to sit on the panel.
And the decision after all the back and forth, after all the arguments, was that?
So there was a unanimous decision
that all of them voted against the application by the former Attorney General.
That Bafuboni ought not to be on that particular.
And so clearly this was a unanimous decision.
Unanimous. Then there was another objection by the former Attorney General, which had to do with the constitution of the panel itself. I think that's what we have just dealt with.
Right.
So it had to do with Bafuboni also. I think we've dealt with that one.
Right, exactly.
So those were the two objections that were dealt with by the panel. They dismissed all two. And then
after this, they moved to the matter of the injunction.
Of the injunction, exactly. So on the matter of the injunction, that was when we had the decision that the president is performing a constitutional duty. And per the Constitution, you cannot enjoin someone from performing a constitutional duty. In fact, there was the issue of timeline that, the case of the former Attorney General was that failure by President Mahama to notify the suspended Chief Justice that I have received some petitions asking for your removal. Failure by President Mahama to do that constitutes a constitutional violation of the rights of the suspended Chief Justice. Now, it was the position of a panel member that the former Attorney General should point the panel to the section of Article 146 that stipulates the timeline within which the president ought to notify the Chief Justice that I have received a petition asking for your removal. In fact, that one is not available. It's not captured anywhere in the Constitution. And so the Attorney General could not point to that particular provision in the Constitution that stipulates timeline during which the president is expected or supposed to notify the Chief Justice once he receives a petition asking for the removal of the Chief Justice. It doesn't exist. And so, again, back and forth, and that was when the decision was made that by 3-2 majority decision, that application has been dismissed by the Supreme Court.
Meaning 3-2, it was not a unanimous decision.
It wasn't a unanimous decision.
3-2 means, in the minds of the two, they had a case.
Exactly. So in the minds of Geu and Henrietta Mensah Bonsu, the argument and the position of the Old Tafo MP, the submission by his lawyer, the former Attorney General, hold some substance. And so they went that direction and they voted that the warrant issued by the president must be withdrawn and the Chief Justice reinstated to her substantive position as a Chief Justice.
And then the other three, led by the acting Chief Justice, is of the firm belief that there is no case.
There is no case, and so they dismissed all the application filed by the member.
All right, let's listen to the former Attorney General Godfrey Dame after the court, after the matters in the Supreme Court. He spoke to the media. Let's listen to him.
Just your initial reaction to this particular ruling.
Well, I think that I find it quite intriguing to start with that the acting Chief Justice himself will preside over the proceedings, and as I indicated, I find it very incongruous because indeed, if at all there's any beneficiary from all of these developments, it is the acting Chief Justice. is a direct beneficiary of this. Of course, it's a constitutional injunction for him to act as the next most senior. But clearly, we cannot lose sight of the fact that whatever has happened, the benefit of it accrues to him. And it is incongruous in the constitutional history of this country. We've never seen any development like that before. Whenever there has been a dispute as to the status of the Chief Justice in this country, start from 1980 for an Attorney General, start from 1983, 94, Aban, and we go to 2005, there about J. Trumelo, the Chief Justice in question, panel the court, but never sat on the matter. I mean, so it cannot be right for the acting Chief Justice to sit on the matter. But that's it. We see the 3-2 ruling, very narrow decision. We wait for the reasons. When the reasons come, we definitely advise ourselves. The narrowness of the decision itself indicates clearly that the application, no doubt, had merit and we know what to do. All right?
Your main argument, your final was the fact that the president's failure to notify the Chief Justice from the outset constitutes an egregious constitutional violation. But one of the panel members pressed you. He wanted you to point the panel to the clause in Article 146 that clearly stipulates the timeline.
The reasons for the decision have not been known. Of course, clearly, I mean, the spirit of Article 146 we're talking about. In the first place, it is important to indicate that nowhere in Article 146 will you find the requirement for prima facie determination made for a Chief Justice. But the Supreme Court itself imported that into Article 146 in 2005 when it authenticated on the J. matter. But of course, the Supreme Court was silent on whether there ought to be notification to the Chief Justice and obtaining of his comment before triggering the process. And that is what is in dispute before the court. And my contention is that natural justice, all the rules of constitutionalism and all will require that there ought to be such process.
Right, so that's the former Attorney General Godfrey Yeboah-Dame, at some point flagged by the Ekwasuman, who was the legal counsel to President Akufo-Addo during the 8-year administration of the president. Now, there was a response from the Deputy Attorney General who represented the state in this case.
Yeah, his point is that the judgment of the court is a position they have held over the period, that indeed there's been no breach by the president has not violated any constitutional provision as suggested by the learned former Attorney General Godfrey Yeboah-Dame.
I get to see the reasoning. So when we see the reasoning, of course, then we will know whether the court recently dissented, the justice dissented, or dissented because there was any basis for it. And there are so many reasons why the court dissented. But you were in court and you realized that the question was consistently put. What exactly are you alleging? What is the right that you are alleging? And to pile up a series of newspaper publications claiming that because newspapers are published that the president is attacking the judiciary, that is enough for the president to stop the process. So the process is unconstitutional because newspapers are published. That cannot be a very strong legal basis. And when you saw the attachments of newspaper publications, many of them, I don't think that publication is a legal right or determines the legal right for anyone.
Okay, so for the decision that has been taken today, what does it mean to the process that is currently before the committee that is supposed to be?
Well, it means the process will go on. The process will go on. The committee would sit, would hear the inquiry into the matter. And of course, I have always maintained that the finding of prima facie case is not automatic that the Chief Justice or the person who is being who is the subject matter of the petition has been removed. It is not at all. So it may come out that the Chief Justice, the petition has not been of merit, and the Chief Justice will be restored to a position. I am always surprised that people have concluded that the fact that prima facie case is found and means that the Chief Justice automatically removed from office. You see, that is what actually motivates this petition, this motion that have been filed. I think the underlying understanding, which I consider a misunderstanding, is that the plaintiff believe that when a prima facie case is established, then it's a gone issue. But it is not.
All right, so that's Justice Rimsai. He is a Deputy Attorney General for the Republic, and he was in court today. Of course, your comments are welcome via our social media handle, X Spaces, YouTube, and of course, my online or Facebook as well. Now, the man who took this matter to the Supreme Court seeking some kind of intervention joins me in the studio this afternoon, Vincent Okwasifwa. Vincent, you're welcome to the show.
Yeah.
And you were a lawyer yourself.
Right.
And so let's start from the very top. Your counsel, in this case, the former Attorney General, had issues with the composition or with the paneling of the judge that sat on this particular case. Why did you raise that objection in the first place?
No, I think that first and foremost, it was not only about the empaneling per se. It was first and foremost about the CJ, that is the acting CJ, sitting as a member of the panel.
And you had issues with
that? That was our first objection.
Why?
Because we believe that for purposes of appropriateness, and so when lawyers or when we say that justice must not only be seen to be done, but it must be done, or justice must not only be done, but it must also be seen to be done.
Right.
It would have been in the interest of Bafuboni. And when I saw him entering the courtroom, I was surprised, like, what is happening? Because the initial paneling, or the initial panel that was supposed to have heard the matter, or that was hearing the matter, was not inclusive of Bafuboni.
Right.
And so our first objection was, why is the acting CJ sitting on the matter? Because it is our respective opinion that he is the beneficiary of the suspension. So it is not about the constitutionality of it. We also did not attack the constitutionality of whether or not Justice Bafuboni could empanel the bench. No. Our case was premised on the fact that please let it be seen that what is going to happen in this room will be fair and will be just. Not necessarily what will be constitutional or what will be legal. And so it was our respective opinion that Bafuboni was not properly constituted to sit on the matter. And for that matter, it would have been in his own interest and the interest of the people of Ghana for him to have recused himself from chairing the panel. Of course, these arguments...
So from the onset, you had issues of bias against him.
Absolutely. That's what I'm saying, that this particular matter is a very crucial and, an important matter where a CJ has been removed.
Suspended.
Has been suspended. And you have been made an acting CJ because of that suspension.
So he's already benefiting from that vacancy.
So why don't you allow other justices of the Supreme Court to sit on the matter so that it will be seen and it will be apparent on whatever is happening that indeed justice is being served, that indeed the process is fair, that indeed whatever is happening is just. And this was our argument, that the appropriateness of it was very critical. You see, you remember what happened in 2012.
Right.
And I use this example not to mean that that is exactly what is happening today, no. But the rationale and the principle behind it, that His Excellency President Kufuor appointed Georgina Wood as a CJ. In 2012, when the New Patriotic Party took the matter
in the election petition
to court, the CJ could have started the matter, but did not, because the party that has brought the matter to court, and if anybody wants to juxtapose this example to that of the 2021, I will also explain to you why it is different. The party that has brought the matter to court, that party's leader appointed her as the Chief Justice. And for that matter, it was proper for her to recuse herself or for her to distance herself from the hearing of the matter so that it will be seen.
Basically because she was appointed by former President Kufuor.
It is constitutional, and it would have been constitutional if she had sat on the matter.
But
the appropriateness of it was what I believe made her believe that she should not sit on the matter, even though she could have sat on the matter.
But again, the response we are getting as the reason why that particular application was dismissed unanimously was to the effect that the Chief Justice perhaps is an office, it's not an individual. And so he's sitting on the panel. He sat there as a member of the Supreme Court, in charge of the faculties, going to discharge his duties without recourse to the fact that he is acting as CJ in the absence of the very person you are seeking to get some clarity on his suspension.
See, if you listen to me very well, I have never said that whatever happened is unconstitutional. In fact, we admitted in court that it is not about the constitutionality of what is happening. It is about the inappropriateness.
In other words, fairness and independent of mind of the person.
Let it be seen. Bring out the confidence of the Ghanaian people, especially the plaintiff, that whatever is going to happen here in the courtroom will be fair and it will be just. And for that matter, you should have allowed the previous panel that was sitting on the case to have sat on it. And that brings me to that second objection.
That particular issue. And so the previous panel had Professor Henrietta Mensah-Bonsu as the presiding.
Absolutely.
Together with Samuel Asiedu, now on the committee that has been set to probe into the petitions against the CJ. And then also Ernest Gau, who is also part. Yao Asare Dakun was changed. So was Richard Ajay-Frimpong. Now the new addition included the acting CJ, Bafuboni, His Lordship Bafuboni, Justice Henrietta Mensah-Bonsu, Justice Yoni Kolende, Justice Amadou Tenko. Interestingly, all the new additions did not find merit in your application before the court.
So you see,
and you think that they did so because of some other interest rather than straight application of the law.
Okay? These are your words. You are a journalist, a neutral person, and you see the kind of conclusion you were able to give.
No, I'm asking you whether you think that
because you have given that conclusion because of what you have seen, not what I am saying. So, in the deepest of your heart, you know that what has happened, even if it is constitutional, you are not seeing that indeed justice is being served. Even if whatever they told the court or whatever they told the parties is constitutional, is legal, and it is even right, in the deepest of your heart, you are not satisfied whether indeed justice is seen.
It's actually not the case. I'm only making reference to the fact that
if you say
I'm also making reference.
Those are your words. Those that were included.
They came in new, and I mean it's a matter of public record that the three new additions voted to dismiss your application. On the other side, too, the other two voted for your application. Will you say that they did so because of whatever?
That is why I'm saying.
In this case, isn't it the straight application of the law that is at play here?
That is why I am saying that if there is an opportunity or an opportunity brings itself for an acting CJ to be able to make sure that in the dispensation of justice, you do not bring into the minds of the Ghanaian that what is happening is not just constitutional, but also just. That what is happening is not only legal, but it is also fair. The bench has that responsibility to create that impression to the Ghanaian people so that we do not have doubt in our justice system.
All right.
And so it was my respective opinion that the acting CJ ought not to have re-empaneled or reconstitute the panel that was already hearing the matter, because this matter has been adjourned about two times.
Right.
Today was our third day in court. The first 2 days that we were in court, this was not the bench. What is so grievous, or what makes those judges that were changed incapacitated to have sat on the matter?
Apart from perhaps the only person some explanation can be preferred is Samuel Asiedu, who is now sitting on a 5-member committee that is looking into the petition against the suspended CJ. The other two is...
What reason do you want to give to Asiedu's own?
He is on a panel.
Because, you see, don't get it wrong. Hold on. He has already been constituted as a member
of the 5-member committee.
No, hold on. He has already been constituted as a member of the bench that was hearing our matter. What His Excellency President Mahama sought to do by including Asiedu in the membership of the committee,
the 5-member committee,
yes, was to replace Asiedu on the bench, which he has no power to do so, because you already know that the matter that is before the bench or that is before the court, he is a member of the panel. Why do you go and add him to the committee? So you see, the point is that Asiedu should rather not be part of the committee. In fact, he should have recused himself from being a member of the committee, because he was already a member. You see why I say...
On this panel.
You see why I say that almost everything that is happening seems to be choreographed. It seems to be choreographed behind the scene. Because why would the acting CJ take off Asiedu? Then, why would the president also make him part of the committee that is supposed to hear the matter of the CJ, knowing very well that Asiedu himself was part of the bench? So,
let me allow...
Justice, unfortunately, I do not see it seem to be done. When on the 21st
I'll come back to you because
because we have not even gone into...
No, we have not. This is just the prelims.
Matter.
Yes, so let me allow other opinions on this particular matter. And of course, former director of the Ghana Law School, Mr. Ansari, also joins me on phone. Mr. Ansari, good afternoon and welcome to the program. We don't seem to have his attention. Mr. Ansari, director of the Ghana Law School. Sir, if you can hear me, good afternoon.
Good afternoon, my brother. How are you?
I'm doing good, sir, and it's good to have you here. So I'm guessing you've been listening to the arguments by Honorable Vincent Asafua, who went to court with the former Attorney General, seeking certain action by the Superior Court of Ghana. Now, the court, in a 3-2 decision, first dismissed the application that was seeking to injunct the president from suspending the Chief Justice. But before that, they had raised issues with the inclusion of the acting Chief Justice on the panel that decided this case, because according to them, he stands to benefit, or he's already benefiting from the vacancy created by the suspension of Gertrude Tokono. What is your take on this argument that they put before the court, which was unanimously rejected?
Thank you very much. You recall that when my good friend filed his application and you had me on your show, I did say it was dead on arrival. The Constitution does not allow the reversal of the speech, where the suspension was done in accordance with. In fact, on grounds of public policy, it is in the best interest of the nation that once a committee has been put in place, the committee will be allowed, to do its work to completion. Nowhere in the Constitution has it been said that anyone feeling aggrieved can go to the Supreme Court and ask the Supreme Court upon an application brought by the person or even through motive to reverse the suspension. Nowhere. And indeed, it would be unconstitutional for the president to even attempt to reverse the suspension. So as far as I'm concerned, that application was one of the applications, with a dead hand, in it. That's my view. Now, having listened to my friend's argument on the empaneling, the CJ, Justice Leadership Tokonu, did empanel, yes, right, because it was, a constitutional right so to do as the head, of the judiciary. Now, there is an acting Chief Justice. And administratively, he alone, that is the acting CE, has the most say now in issues of empaneling or composing justices to sit on this matter. Only the acting CJ, no other person. In the absence of the acting CJ, the most senior justice of the Supreme Court will have to carry out that administrative duty. So no one can fault the acting CJ for deciding to sit. The CJ could have sat, and in fact, on many occasions, we have questioned why the head of the judiciary has not been sitting. Justice Georgina Wood used to recuse herself for reasons best known to her. But that doesn't mean that other justices must toe her line. If Paul Bafuboni feels that he has to sit and he has sat, I mean, it is within his constitutional mandate so to do.
But in terms of the morality of it,
that the applicant may go further and ask for a review of these decisions. So let us not go into the merits as to why they do that. But let us ask ourselves a simple question: does the Constitution allow a reversal of the suspension? And if so, which particular article in the Constitution says that after the president, has suspended the Chief Justice, an application can be brought seeking to reverse the suspension? Where is it, written in black and white in the Constitution? If it is not there, it means it is not there, and therefore it cannot be done. Simple.
I was thinking I can have you some few minutes on the issue of fairness and the proprietiveness of the inclusion of the acting CJ on the panel that decided the outcome of this application, and the fact that the lawyers for the applicant makes the point that for fairness and neutrality to prevail, he should not have been part of the panel because clearly he's already benefiting from the absence of Gertrude Tokonu.
Well, for fairness and neutrality, the application ought not to have been brought in the first place. But to answer the question, there is a doctrine in law, known as or referred to as the doctrine of necessity. Necessity. And acting upon the doctrine of necessity, the Chief Justice or acting Chief Justice may decide to sit. And it is not wrongful, to do so.
Even though he may be conflicted in a way.
For the CJ herself to sit, or for the acting CJ, and it is fair. Fairness is relative.
Even though he may be conflicted in a way.
It is not objective. Fairness is in the mind of the sayer or user of the work. I'm saying that the doctrine of necessity allows the acting Chief Justice or even the incumbent Chief Justice to sit. But if she had not been suspended and she chose to sit, students have erred, and therefore, if in like manner the acting Chief Justice chooses to sit, he hasn't erred. So the issue of fairness does not arise. It is a constitutional mandate. The Constitution mandates the head to empanel, the head herself or himself inclusive.
And then on the substantive matter, 3-2 the outcome, meaning that, it is a matter that could have gone anyway. It was not a clear-cut decision for the panel. Some held the view that the applicants had a case. The 3 additions that came through, all voting against the application.
Well, I'm saying that as a lawyer, the application was legally, wholly unmeritorious. It was without, any merit. And I said the day it was filed that it was dead on arrival, and I reasonably expected, any bench to throw it out because, it has no support. It cannot find any support in the Constitution. Allow the process to continue to completion so that it will be a precedent and it will prevent people from just submitting frivolous and vexatious petitions to the president. So let's allow, the process, to come to, a completion in order to know whether the allegations, are meritorious or not. Maybe, there's nothing in the allegation, and then the petition, will fail, and the CJ, will be asked to resume. If there are merits in the petition, on the other hand, and the petition succeeds, then the CJ is removed. Let us allow the process. Now, if we curtail the process, tongues are going to work as to why the president did that. I'm for a full implementation of what is going on. Let us see it to the end, and then we know whether what has been said about the CJ is true or false. If you curtail it, it will be lingering in the minds of the ordinary Ghanaian. What kind of justice system is this? Let us avoid that.
All right. Let
us see it to the end, and then we all know. But as to whether it is fair for A to state or B not to state, I leave it to the judicial conscience of the individual justices who sat on the matter. All it's right. Not for we mortals to say so. It is for they themselves. If it is fair for them, or there's some merit in the applicants saying that they shouldn't have started or not, we'll leave it to them. It is not for us to say so.
I appreciate your time very much, Sir. Kwaku Ansansare is former director of the Ghana School of Law. So, Vincent, we've heard him
saying the same thing. Are we not saying the same thing? I sat here and told you that we are not questioning the power of the the acting CJ, to empanel the judges. We are only saying that, as the saying goes, please let justice not only be done,
but to be seen.
But let it be seen to be done. Okay, breathe in confidence in our judiciary. Make sure that the integrity of the judiciary is intact, so that any bystander anywhere, when he sees what is being done in court, may not only be interested in the legality or the constitutionality of what is happening in court, but will also see the need of fairness and justice. And so that's the point I've been making. And I think that we've said the same thing. The only thing that he is saying that is different from mine is that my matter was dead on arrival.
Yes,
you know
that is what he says.
That it cannot be dead on arrival because we are having 2 justices at the Supreme Court who see reasoning
with your position,
the potency of the arguments that we made in court. On what basis can he say that our matter was dead on arrival? It cannot be. The point that I have been drumming home is that every CJ or any person who is acting in his or her stead has the same power to do whatever the CJ will have to do under the Constitution of the Republic of Ghana. And so, our objection was in no way stopping the CJ from doing what he ought to do. But it would have been appropriate, it would have been good for his own integrity, for the integrity of the court, for the confidence of the Ghanaian people, to see that whatever was going to happen in court was going to be just was going to be fair. It was not only going to be constitutional. It was not only going to be legal, but the Ghanaian people will see that indeed we have a justice system that is robust, and that is our point, and that is what we were seeking. And I cited this example to you, even apart from the Tufo versus Attorney General and the J. Trim examples. I cited an example to you in terms of the principle as far as Georgina Wu's situation was concerned and how she handled the matter. Nothing has stopped Georgina Wu, the former Chief Justice, to have sat on the election petition that the New Patriotic Party took to court. Nothing has stopped her. Nothing also has stopped her from even empaneling the sort of judges who should sit on it.
Right.
But see, if you are an acting CJ and we have a panel of judges that is sitting on the matter, then as soon as you have been appointed, you change the members. And all those members that you brought in, including he himself, voted against our injunction. Whatever the basis may be, and listen to me very well.
And the reason they say will come out on the 21st of May.
As an officer of the court, whatever the basis may be, it may be constitutional, it may be legal, but in the minds of an ordinary person, have you been able to create that impression that there was fairness, that there was just, and that I, as a Ghanaian, and even investors should have confidence in the judiciary or the justice system?
The reason, unfortunately,
that threshold has not been met. And it is disappointing.
The reason, unfortunately, according to the court, will come out on 21st of May. So it's unclear the reason behind the decision they took today. But you were in court seeking what exactly? To get clarity as to what time a sitting Chief Justice should be told of a petition against him or her?
You remember we went to court on two matters. The first injunction application that we sought from the Supreme Court to hear our prayer was that the Supreme Court should stay the hands of the president from proceeding on the processes that it has started. Because at the time, you remember, His Excellency the President, upon receiving the petition, had not ferried the petition to the Chief Justice. The February letter that emanated from the office of the President only said that they have triggered the consultation processes. Our position at the time, which we did so by way of the initial injunction, was that please stay in the hands of the president. But today, when we went to court, we withdrew that aspect and went ahead with our second interlocutory injunction, which sought to suspend the suspension of the Chief Justice. What was the basis? Our basis is that, yes, Article 1466 says that the automatic procedure that should follow after a president of the republic has received a petition is to go and consult the Council of State. That is what Article 1466 is saying.
Right.
But you and I know that the Constitution since 1992 needs review, and for that matter, case law has come to, as it were, fill in the lacunas that we find in our Constitution. So my submission to the court was that anytime a petition is received, the president ought to ferry the petition to the CJ even before any consultation whatsoever will start.
And the court asks you in this case, because you took this matter to court,
right,
to point out the exact provision in that article that talks about timelines within which the CJ should be informed.
You see,
and from what we have been told.
That was why I was scandalized, and that was why I was surprised. And with the greatest of respect, it was coming from my own boss, someone I practiced from his own chambers. When Kolindi was asking this question, I was surprised why he was asking that we should point to him in the Constitution.
Because there is none, actually.
Listen, please. When you are supposed to find a prima facie against the president, do you find that in the Constitution? Against the CJ, do you find that in the Constitution?
No, not exactly.
Today, if there's a petition to remove the Electoral Commission, has that process been well defined in the Constitution? I'm asking you. Today, if there's a petition against Jane Mensah, the Constitution has not provided for any procedure to remove the Electoral Commission. Mm-hmm. Is that not the case?
It is.
It was a matter of case law, one, and interpreting the Constitution purposively in accordance with the Interpretation Act of Ghana, that in interpreting the Constitution, you need to do so by way of the combined effect of the letter and the context. And also, when SOA, JSC said in the 24 versus Attorney General, that in reading the Constitution, please make sure that you do so by the letter and the spirit of the Constitution. It is on that basis that a lot of meanings have been read into our Constitution to give meaning to it so that it does not result into absurdity. So I disagree with the court when the court even asked that question, that because it has not been stated in the Constitution, then it means that that is not legal. No.
So, Honorable
that is not our jurisprudence.
So, Honorable Asafo, what is next for you as far as this matter is concerned, or the case, or the door is closed?
Well, the door cannot be closed. If you meet a bench, 5-member panel, who says that the potency of your argument is apt, and for that matter, I go with what you say, 2 of them. 3 saying that I disagree with you. It only gives me some impression, and it gives me some comfort that the reasoning for me going to court has some merit. And so
you're going for a review?
And so, if on the 21st of May, I see the reason behind the ruling, then if I'm not satisfied, then I am likely to file for a review
of this case.
For the court to review its own decision.
All right.
That the decision that it gave cannot be made to stand. It does not bring about the kind of fairness and just that we want to see in our judiciary. We'll
leave it here for now and wait for the decision or the reason behind the decision of the court to be made known on the 21st of May, and then we'll further the discussion on this matter. Let's take a short break here on the point. When we return, we'll talk about the police and what they've been telling us this afternoon. Vincent, thank you so much for coming through.
Thank you so much.
Welcome back to the show. This is The Pulse. My name is Elton Brobe. Now, let's move away from the court, but another related matter. The Criminal Investigation Department of the Ghana Police Service says it has begun reviewing a viral video allegedly showing Minority Leader Alexander Afenyo-Markin assaulting a police officer to determine whether there is a case for an assault. Now, the incident is reported to have occurred on Monday, May 5, 2025, during the Save the Judiciary demonstration. While the Minority Leader has publicly explained his version of events, the police at a news conference maintained that investigations are ongoing to verify the facts. We'll hear from the police shortly, but my colleague James Aveji is just returning from that news conference, and he joins me in studio. So, James, this news conference was about what exactly?
This was a news conference held by the CID Department of the Ghana Police Service. All we have had in the past few days has been addressed by the Director of Police CID, but this one was addressed by the Director CID, and it focused on 3 key issues. The rescued 2 women who were kidnapped in Nigeria by some Nigerian men, right, and the issues that are unfolded.
Is it the same one that Yoko reported some time back?
Exactly. And so they told us the collaborative work that happened between the police, the Yoko, and then the Nigerian police. And then the issue about the Chinese who were also kidnapped on high sea by some pirates. And then the third one was some killings in the central region, which some arrests have been made. So that was the main focus of this particular press conference by the CID.
And then, and so on that score, the kidnapping matter, what is the CID doing about it? Are they going to put these people before court?
So as we speak, the police have not been clear on who amongst the cartel of people, quite a number of people have been involved in this. They are not clear which of them are before court, but they have been detailing how this happened, attributing part of the issue to a collaboration between some employee of one of the telecommunication networks who aided a Momo vendor in the Upper East region to register some mobile numbers which were used in all of this coordinated syndications leading to the kidnapping of these two women. So these are two separate women who traveled from two separate locations but landed at the same location in Nigeria. And so we can listen to the police director of CID, DCOP Lydia Yakudonko, tell us how all of these people coordinated to actually kidnap these two people, and then we'll get the rest of the details.
Right.
What I can say is that we are still sustaining those operations. We haven't relented in our efforts to ensure that our waters and forests. After the interrogation of the suspects, it came to light that suspect titles. And what I can say is that we are still sustaining those operations. We haven't relented in our efforts to ensure that our waters and forests are safe. We have officers in a number of regions who are sustaining that exercise. We've made a number of arrests. Suspects are being put before court, and we continue to continue with that. The election collation, as Director of Public Affairs said, if the EC is ready, we are always ready to provide the security. So I believe that they will take it up with the Inspector General of Police, but the service is always ready to provide the needed security support for any exercise, whether it's the EC or any other institution. Somebody asked about the Honorable Afenyo-Markin case. I believe that we also, or there are videos in social media about an altercation or confrontation that happened during the demonstration. We captured it on our lenses as well. So it's a matter of investigation. If it's an assault, if it's a tussle or a confrontation, whatever it is called, it has to be investigated. So we've commenced that investigation. We've written to the Right Honorable Speaker of Parliament because he's a sitting member of Parliament. We've identified the police officers who were on duty at the scene. We have taken statements and we'll definitely update you in due course.
Right, so that's the CID boss. But again, let me refresh your memory, because this morning, remember last night, the police issued a statement on their social media handle saying that they've written to the speaker so that they can have access to the minority leader and ask him some questions. And then the minority leader issued a statement, a long statement, saying that he was rather the victim and not the attacker in this case. Now, before 11, he issued another statement, formally petitioning the police to investigate and take appropriate disciplinary action against one Constable Forsem, a tall, fair, and heavily built officer who was stationed at the entrance of Parliament to provide security during the Save the Judiciary demonstration. He said Constable Forsem assaulted him at the entrance of Parliament House during the demonstration. And to address this incident and to correct misleading narrative circulating in the public domain, he has issued a public statement detailing the event as it occurred. So this is what Afenyo-Markin is asking the police administration to do. James, I'm wondering whether the police are aware of the statement, whether they've taken statement from the officer involved, and whether they've gotten a response from the Speaker of Parliament.
Thankfully, although the police stay away from acknowledging whether they have received this letter from Afenyo-Markin, they indicate that all the officers that were supposed to be stationed at where the incident happened have all been identified,
right.
And statement has been taken from all of them, which will also aid in the investigation.
And finally, before you go, this disturbing issue of Momo vendors being killed by armed robbers. What is the police response to this?
So in this particular case, it is a Momo vendor that linked with an employee of one of the mobile network operators, who the mobile network operator employee gave him access to the registration, the back end of the the SIM card registration of that network,
right,
allowing the suspect in question to register a number of numbers which were used to receive and send monies from a relation to this kidnapping. The DCOP has been explaining how this team of cartel coordinated the actions to lure these women into Nigeria, which they have actually linked to romance scam, warning the public against some of these things.
Interrogation of the suspect, it came to light that suspect Titus Imba Awuni, who is a mobile money agent in Bolgatanga. The suspect had links with one Abdul Mubarak Zakaria, an employee of one of the telecommunication companies, who has allegedly given him his official login credentials and also forwards a one-time PIN for two-factor verification to him, which he uses to log into the SIM registration app of the telecom company to register subscriber SIM cards with other people's Ghana card details without their consent and sell same at 150 Ghana cedis each. Suspect Emeka Christian told police that in April 2025, he invited suspect Basil Okonkwo from Nigeria to Ghana to assist him to do business and gather money to perform his father's funeral. He added that one Peter Okoye called him and requested his mobile money number to receive some money. He forwarded his MTN number to him, and thereafter he was informed by suspect Peter that he had kidnapped some Ghanaian ladies who are with him in Nigeria. Hence, he will use his mobile money accounts to collect the ransom, which he obliged. Later, Peter Okoye called that he needed an additional mobile money number for the same purpose. He then went to Titus Imba Awuni again and bought another SIM registered in the name of Alfred Amalbio and forwarded same to Peter Okoye. He claimed in all he received 5,000 cedis, another 5,000 cedis, and another 3,200 Ghana cedis, totaling 13,200 Ghana cedis through MTN number 053-663-0088. Out of the amount, he took 900 Ghana cedis for himself, 150 Ghana cedis for transfer charges, and then he transferred the balance of 12,250 Ghana cedis to the said Peter Okoye through a phone number registered in the name Mama Mahase Nimate. The money was then converted to Naira and sent into a Nigerian bank account provided by suspect Peter Okoye, bearing the name Cecilia Williams. Upon the arrest of suspects Christian Emeka and Basil Okonkwo, both Nigerians, the Ghana Police Service was able to establish the identity and true address of suspect Peter Okoye, who had custody of the victims. These details were then shared with Interpol Nigeria, and they aided in the tracking and arrest of the three suspects: Peter Okoye, 31, Polenos Chidokwe, 35, Chinonso Okafor, 35, in Port Harcourt, Onitsha, in Nigeria. The two victims, Anastasia Bedu Atta and Evelyn Sewa Kunedu, were then rescued.
And that's the Director General of the CID, DCOP, Lydia Donko, speaking there. There's also the matter of the romance fraud.
Yeah, exactly. So these two women, the police have told us, actually got in touch. The kidnappers actually got in touch with them through Facebook, offering, relationship to them, for which reason they traveled from Ghana to Nigeria and then ended up in the situation they have ended up before the police have been able to rescue them.
Suspects Peter Okoye and Christian Emeka, both Nigerians, indicated to police that they were in Ghana in the year 2019 to work with QNet. They left Ghana for Nigeria in 2020, but Christian Emeka returned to Ghana in June 2024. Peter Okoye, Christian Emeka, and Basil Okonkwo are all Nigerians. They were into romance scam both in Ghana and in Nigeria. They operate through their Facebook and other social media handles. These suspects met the two victims, Anastasia Bedu Atta and Evelyn Sewa Kunedu, through their Facebook accounts. Suspects posed as white men who wanted to marry the victims. The two unsuspecting victims became convinced, accepted the marriage proposal. The suspects then lured them to Nigeria, and the victims traveled separately but ended up at the same location on the same day on 22nd of April 2025. On reaching the location in Nigeria at Port Harcourt, Onitsha, Peter Okoye and his two accomplices kidnapped them. The three suspects stripped the two victims naked, tied them up, assaulted them with cutlasses, threatened to kill them with a knife, wrapped them in an orange bedsheet with their heads covered with black polythene, and threatened to hang them with a nylon rope. All these violent acts perpetrated against the victims were recorded on video. disseminated on social media, and also a copy was sent to the victims' families with a demand for ransom of 500,000 cedis from each of the victims' families. A total of 18,000 Ghana cedis was paid to various phone numbers from the families. As of today, both suspects and victims are with the Nigerian authorities, and efforts are being made to transport the victims to Ghana and also extradite the suspects to Ghana to assist investigations. At the moment, information received from our counterparts in Nigeria indicates that both victims are fine and they have received routine medical checks. Further updates will be communicated when the victims are received in Ghana and we are able to listen to them and hear their side of the story. While we celebrate our success stories, it is also a good time to call on all of us to exercise extreme caution when we are online so as not to fall victim to fraudsters who take undue advantage of unsuspecting persons. Do not believe everything you see, hear, or read online. As always, be on the lookout for scammers and fraudsters who seek every opportunity to prey on your innocence, ignorance, or failure to do due diligence. And finally, we wish to advise that you report any suspicious activity to the police for appropriate action.
The Director General of the Police Criminal Investigation Department, CID, DCOP, Lydia Donko. Now, from police, let me turn attention now to the Ghana National Fire Service, where there's growing concern over attacks on personnel, and this has sparked serious uneasiness among staff. Now, these incidents are partly linked to delays in emergency response time, delays that some public safety advocates argue are beyond the control of fire service. Now, this afternoon, the fire service has a campaign to draw attention to this and the need for people to desist from attacking their personnel. Joining me in the studio to discuss how these challenges and attacks are affecting morale within the Ghana National Fire Service, Accra Regional Fire Commander, AFCO2, Rashid Kwame. That's you. You're welcome, my brother.
Good afternoon.
And I trust you are doing good.
Very good. By the grace of God.
I thought with public education, attacks on your personnel, may have come down.
It has not improved. It has not improved.
So what really is going on here?
So we have a series of attacks. I am taking that. Let me take this advantage and extend my warm message, greetings to the Chief Fire Officer, Madam CFO Daniela Maosisa.2, and then the personnel of the Ghana National Fire Service, particularly Greater Accra Region, who are putting their lives on the line for the safety of others. Seriously, these things, just like you said, they affect the morale of personnel.
Right.
And that is the reason why this year's International Firefighters Day celebration that we marked, that was yesterday on the 5th of May 2025. I took...
So even globally, the acceptance is that fire service personnel are always under attack most times.
Actually, the celebration is globally every 4th of May. Every 4th of May is declared International Firefighters Day.
Right.
To celebrate these heroes, the firemen who have fallen in line of duty, and those who are hurt and so on. So it's a global thing. But because on the 4th of May fell on Sunday, we celebrated it on yesterday. That was on the Monday. And then the theme for this year's celebration is we're appreciating our firefighters, say no to assault on firefighters, and then truck vandalism. So that is
how bad is the situation?
It's bad because I just have to give you only just in Greater Accra here.
Right.
On the Tuesday, 5th January 2025, Abelimpe Fire Station responded to a distress call at Abeka, a place called Free Pipe, and they were pelting them with stones.
Why? Because you did not come on time.
That is their mind. That in their mind they felt that we didn't come early. Then on Thursday, 3rd April 2025, to Trade Fair Fire Station also attended the fire at a place called Teshi Gono School near the drugstore. A similar thing happened. On the 5th of September 2024, Dansuman Fire Station, also around Dansuman roundabout near Zodiac, a similar incident happened. I can go on Anya Fire Station, Ajin Kotoku Fire Station, Circle Fire Station, Ministries Fire Station, As I speak, the one even at the ministry's fire station is still in the hospital.
What happened to him?
No, he had a clash with some of these public who come around there when firefighting is going on, and then they use a stick to hit, a metal to hit his leg. And up to now, he's still limping. He's still down.
So all of these assaults are linked to your men whilst in active duty in terms of controlling or fighting fire?
Yes. Yes, they are linked. They are linked. And these things have negative effects. That is the more reason why I have decided that this afternoon I will come here and talk about it, and then call on the authorities and call on you, the media, to say no, to tell the general public to say no to some of these things. Because
but beyond Accra, Commander, what is the picture like?
Oh yes,
in the rest of the country?
I remember when I was in Ashanti region, I had to go to court at this place, Kwadaso Circuit Court, on some of these issues. Firemen were attacked in Konongo. Firemen were attacked at race course, a whole lot of places. Even recently, I saw a video that the firemen were coming to extinguish fire around the magazine area there. The people started and they had to. So these are the challenges.
But I'm thinking that the reason has always been the same. Either you did not come on time, or when the officers went on the scene, they went there with the water in the fire engine. These two reasons have always been the reasons why some of your men are attacked.
Yes. So let me see if I can attempt to address this.
Right.
If you are talking about the time of calling the Ghana National Fire Service, the time of calling the Ghana National Fire Service, it is your place that is on fire. Mm-hmm. So what we have is the time that you called us. But I can assure you that as an expert, the time that you called us is not the time that the fire started. We have time of call and we have time of discovering the fire. And I can tell you the time of discovering the fire is not the time the fire started. Mm-hmm. Because the fire might have started long time before you discovered the fire.
Right.
And when you discovered the fire, you also made an effort to put out the fire. Before, when the thing gets out of hand, you call on fire service. So looking at the time of that you call the Ghana National Fire Service, that is the time of call. Then the time we will respond to the time that we get to the fire scene there, looking at the time that the fire will come under control. So then what it means is that if you don't put in a lot of fire safety measures, mm-hmm. and your fire is not detected early, because we don't have the mechanism where we will sit in our office and foresee everybody's home that, oh, Elton's place, excuse me to say, is having a challenge.
Right.
Let's go there. Mm. It is you who has to call us. And like
but usually, what is your standard reporting time?
No, average response. We've made improvements. Average response time normally is 7 minutes.
7 minutes.
Yes, but sometimes even places like the last time I was talking about Tiptoe and other places where fire stations are very close to the place that is burning, it takes like a minute or two, and the men are there. So most of the time, what I have realized is that it is about how the detection of the fire. So then you have to make good use of smoke detectors, flame detectors, heat detectors.
All right.
So that in any case, any time that there is the slightest smoke in your room or in your business or wherever the fire occurs, quickly an alarm will trigger. Then all the occupants will know that this place
something is happening.
Good. Then quickly the call will be placed to fire service. But a situation where people will be there and somebody will say, something is smelling, some rubber is smelling around. They will be there and something is smelling around before you realize that there is actually a fire outbreak in the house. Then it means the fire would have reached its developed stage.
That is difficult to control. It is at that time they'll put in a call to the Ghana National Fire Service for you to respond. Call,
it also depends on where your house is located
and the nearest
fire station. Mm-hmm. Here is a situation in our country, wherever anybody finds a piece of land, he puts his building, and then he's staying there. So if the person is staying at the outskirts of town,
right,
and he happens to place a fire caller from here to maybe a Sam or a Brio or something, you have to commute from where you are to the place.
So from the Ghana National Fire Service point of view, what is the best way to address this?
The best way to address these things, one, is to make sure that more fire stations are built so that we'll get closer to the people.
Right.
And I also advise that if you are living close to, if you are living in Medina, go to Medina Fire Station and get the number. Put it on your cell phone. If you are living in Dansoman, go to Dansoman Fire Station. If you are living around Seke Kukumlemle here, go to Seke Fire, so that if there is an outbreak of fire, then what you can do is that you can call direct to the control room, then we can respond. Right. But if you sit somewhere and then you think that we will not be able to know that
something is happening. Again, if you can walk us through the hashtag. So that
so the hashtag is hashtag say no to assault on firefighters and truck vandalism. And I've told you, I'm passionate about this.
Of course.
Because you see, these things has a financial toll on the state, because these machines doesn't belong to us. They are not even there, and the little that are there, you are vandalizing them. It demoralizes personnel that you know that you are going to fight fire and you are not sure that the person is going to appreciate you and get up and be pelting stones at you. I mean, it can result in physical injuries.
Right.
Like I said, people are hospitalized and deny innocent people who may also need some of these equipment that we can use. So these are some of the challenges that are faced, that I think that the media should join hands for us to.
And of course, my Joy News Multimedia, we are on board with this hashtag to reduce these attacks, possibly eliminate it completely in the society. Yes. Commander, thank you so much for coming through. Okay. I appreciate your time so much. Yes, and that's the Greater Accra Regional Commander of the Ghana National Fire Service. And again, the hashtag is stop.
Yes, say no to assault on firefighters and truck vandalism.
Right. We'll leave it here, but we'll continue. It is just the hashtag that we are talking about today. In the days to follow, we'll dwell more on the matters. Let me move to other stories. And Communications Minister Samuel Nate George has reviewed a decisive government move to protect Ghana's fiber optic infrastructure by integrating it into national infrastructure planning policy. Now, addressing the 24th Ghana Telecommunication Chamber Forum on the theme Leveraging Fiber for Accelerated Development in Accra, the minister said fiber networks must be treated as a critical national asset, just like water and electricity. The Ghana Chamber of Telecommunication and Electronic Money Issuers Chamber of Ghana disclosed that between January and November last year, there were a total of 10,223 fiber optic cable cuts across the country, costing them $17.4 million to repair.
Optic infrastructure is a silent engine powering Ghana's digital economy. Yet, without standardized specifications, we risk fragmentation, continued destruction of this critical information infrastructure, inefficiency, and high maintenance cost. This initiative is crucial because it reflects the coordinated forward-looking planning required to realize Ghana's full digital potential. These specifications, covering everything from trenching depth and pole span to duct types and splicing procedures, will now ensure uniformity, safety, and interoperability across our fiber deployments, both underground and aerial fiber. Standards and specifications matter, especially as we push towards increased broadband coverage in rural and underserved communities. But let's be clear on one thing. Our fiber infrastructure must be protected. That is non-negotiable. It is a national asset. Just as we protect roads and water pipelines, so too must we safeguard the cables that carry the lifeblood of our digital economy, data. Destructive digging, uncoordinated installations, and poor maintenance must become things of the past. They must actually become relics of the past. Again, as is done for electricity and water, communications, which is now a utility and a human right, should be treated as such. During roadworks, just as water and electricity are catered for in relocation, fiber should also be treated in a like-minded manner, and I've begun conversations with the Minister for Roads and Highways on this subject. As a ministry, we're working closely with other government agencies and regulators to ensure that our fiber optic deployments align with Ghana's urban planning, our road construction, and energy infrastructure development. We're committed to harmonizing policy, enforcing compliance, and encouraging innovation.
Well, the acting Director General of the National Communication Authority, Reverend Engineer Edimoyirenchi Fianko, has also proposed that the new bill seeking to criminalize fire cuts should include punitive measures such as charging corporates triple the cost of the damage caused.
And we have also made recommendations to the Honorable Minister of Communications. He has, directed all the agencies to review the laws around the sector, like the NCA Act and the Electronic Communications Act have been in existence for over 17 years. By looking at the fast-paced changes in the industry, we need to also bring the laws in alignment. And I mentioned in my address that one of the proposals we have made is to, we've recommended an amendment to Section 77 of Act 775 to recommend administrative fines, for people who recklessly damage, if you damage a fiber cable or any communication infrastructure, our recommendation is that you be fined 3 times the cost of repair. This is intended to make people extra careful when they are, working around areas where we have these fiber cables and other communication infrastructure laid. In the event you don't pay the fine, we recommend that you be prosecuted, criminal prosecution, and upon conviction, you being liable to a fine of a penalty of not less than 10,000 penalty units, or 5 years imprisonment, or both. We think that until people get punished for these things, nobody will be deterred. And every time a cable is cut, it has an impact on service quality. So you can have whole areas, sometimes whole regions, experiencing disruption in the voice and data services because there has been a cable cut. Even though we built redundancy, sometimes we have double, triple cable cuts, and the impact can be very significant on quality of service.
Well, the president of the Ghana Telecommunication Chamber, Kenneth Ashige, Dr. Kenneth Ashige, joins me via Zoom. So, Doc, this is revealing, over $17 million in fiber cuts. That must be draining the telecos. Yes, Doc, if you can unmute for me.
Sorry, thank you. Thank you very much. It's actually a $9.2 million
right
spent in fixing fiber cuts. And you know that that's money that we could have used in extending fiber to my holy towns of Chiama and Asadama. And we are spending all of that just repairing fiber cuts. And not only is the issue of the cost, but also the challenge that you and I as subscribers face. Because you might be making a call, a critical call, it does not go through. Data services are poor, financial services get impacted. For broadcasters, for example, there's a lot of work that you currently do using data and all of that, and that is compromised. So the big thing is about the impact on our subscribers. It's about the impact on national development, and it's a major national security concern. Because once those infrastructure goes down, what then happens is that anybody else can do anything at that particular time.
So basically, is it a case that the cables are so exposed, unprotected, such that anybody at all can just mount, cut, and then use it for whatever they want to?
You see, so if you look at the data, about 21% of the cuts come from road construction. So they're doing a road construction, and then as they're doing their excavations, they cut the cable. Unfortunately, fiber is not like electricity. That is at high voltage. It's extra low voltage. So when you cut it, when you touch it, nothing happens to you. It is also not like water, that if you touch water pipes and you're doing construction, it will flood the place. So you will not be able to continue your work. And so because of that, the negligence around it
is so high. And another challenge you also face is that some people still have the impression that when they see these cables that are telecommunication cables, they might have copper in them. So about 14% of the cuts are coming from theft and vandalism. And then you have private developers also close by. So somebody is constructing a fuel station, for example. And let me give you a typical, somewhere around the Dawa area, there were some people constructing their cables. So you talk about whether the cables, the cables were not even buried.
Right.
So it's not as they're in the ground. They are on poles. We call them aerial fiber. The person went and cut all the poles and then destroy the cables. And for the fiber as well, what we do is that when we dig about 1.2 meters and bury them. And then you will put a sand bed on it, you put a warning tape on it before you backfill it. And, there are times where our people might even be on site, supervising the work others are doing. But because when they cut it, nothing happens to them, they will not be shocked, the place will not be flooded. They do it with reckless abandon. And also because we have not had a situation where people are punished punitively for the damage that they do, people take it for granted. But we're happy that the current minister, is very serious about getting this legislative instrument passed. And then we've been told today that the NCA itself, in its recommendation to the minister, is also recommending punitive action. So it is important that we all safeguard our telecommunication infrastructure and ensure that, this we are doing via Zoom. If it was not for internet, it would not be able to happen.
That's true.
And we all remember that on the 14th of March last year, the whole country came to a standstill because of the challenges we had with our undersea cable. Normally, when you don't have power, you'll be able to get a generator, you'll be able to get solar. If you don't have water, a borehole somewhere, you can go and fetch water. But when it comes to telecommunication, that day it went down. There was nowhere else you can get it. And as much as now we're working after that incident, the NCA has given directives to be able to ensure not only redundancy, but resilience. It is important that all of us find ways in which we safeguard our fiber. So it's on the back of that that we also recognize the fact that as industry, we also have a role to play. How do we ensure that fiber installations are done to some minimum standards? So as an industry, we've done some self-regulatory thing, and we've come up with a minimum standard and specification for fiber installations. Fortunately for us, the NCA Director General has taken this with endorsement of the Minister for Communication and is going to be converted into a national standard. So that now, we will have a standard by which all of this will be done. And all of this is to ensure that we stop this damage to infrastructure.
And I wonder, this bill that is coming up, whether there will be punishments or there will be some kind of responsibility placed on contractors who's in their quest to construct a road would damage some of these cables. Because in the absence of punishment for them, I think they will just do whatever they want.
We have some laws that are scattered all the way, but in this proposal that the NCA is making to the ministry, which I am pretty sure the minister would also carry out, what is going to be in it is that once you cut the fiber, the proposal is for an administrative fine.
Right.
So if it's considered the fact that 9.2 million have been spent, then for all of these people, they should be paying us about some $27.6 million in terms of the administrative fine. If they fail to do that, then the case would then go to court and they will be criminally prosecuted. If they are found liable, they would pay up to 10,000 penalty units, or they will go to jail up to a maximum of 5 years, or both. And for us, it is a good sign, so that, as you said rightly, people would now know that there are repercussions for doing these things, and it's not something that you can get away with. The UK, for example, passed the Telecommunication Security Act in 2021. They have also done the same, where they are making it very punitive for damaging telecommunication infrastructure. So I think it is a good step that the acting Director General of the NCA, and then under the the supervision of the Minister for Communication, are going to bring, and it would help all of us. What it will do for all me and you as subscribers is that the quality of our calls and our experience in using telecommunication infrastructure will be improved. It could even result in cheaper data prices because this $10 million that was spent, if the telcos don't have to spend that, they could then reduce their cost so that they will be a bit more competitive and get a lot more people using the service. So for you and I as customers and as citizens, it would inure to our benefit.
We'll leave it here for now, but we all need our telecommunication companies to be at their very best because we've gotten to this stage in our lives where telecommunication, internet is something that you can definitely not live without. And so we'll leave the conversation here, but we'll look forward to that bill going to Parliament, and when passed, then the punishment regime will start. Dr. Kenashibe, thank you so much for your time this afternoon. Folks, this is where we'll part company, but there's more stories on myjoyonline.com. If you should visit. Now, Supreme Court dismisses Godfred Dame's objection to acting Chief Justice presiding over Tokonu's suspension case. There's also Foreign Affairs Ministry revoking 701 diplomatic and service passports. And Afenyo-Markin petitions the Inspector General of Police to probe constable forcing. Folks, those are the stories on myjoyonline.com. There's more news on Top Story, on Newsnight, on Joy 99.7 FM, and of course, Joy News Prime here on Joy News. But that's our show for today. Whatever you are up to in the hours ahead, I hope is profitable. Same time tomorrow, we shall be here to bring you another exciting edition of The Pulse. Until then, my name is Elton Broby. Have a good evening and take care.